I would like to give the floor for the co-referrator of this presentation, Professor Tamás Korhecz. Tamás, the floor is yours.
Thank you. Mr. President, dear participants, I will speak exactly 15 minutes according to the schedule, and I will apologize because after my presentation I will leave the conference. I will reflect to some issues. There is no time to elaborate in detail the complete problem of national symbols, state symbols, and minority symbols in Serbia, but I will reflect on some questions that was analyzed by Professor Đukić. But before I reflect to some particular issues, I will try to give an introduction in which I will point on why is a sensitive and challenging issue to regulate state symbols, national symbols, and symbols of nationalities or minorities in a nation state like Serbia or any other nation state with substantial number of minorities living traditionally in these nation states. So where is the challenge? State symbols are marks, signs, and they express state sovereignty. Having in mind that state sovereignty means a supreme power and also mean that sovereignty is not dividable. It is the protection of state symbols is also a protection of the sovereignty. And when we speak about the use of the national symbols, use of nationality symbols, foreign states or regions, it's always a sensitive issue to which extent to legalize, to accept the protection of the use of these symbols alongside, parallelly with the symbols of the state. The next problem is that state symbols, primarily the flag, but also the coat of arms and the anthem, are often symbols of the nation as well. So they are also national symbols. And in East Central European borders, national symbols and nation means a state bearing a dominant nation. I mean, it not means all citizens of the state, but it means the Serb nation, it means the Croat nation, it means the Slovak nation, and not all the citizens feel that they are belonging to the Slovak nations who are living in Slovakia. So I'm not belonging to Serb nation. I'm the judge of the Constitutional Court of Serbia, but I'm not belonging to the Serb nation. I am member of the Hungarian national minority in Serbia. And hundreds of thousands of the citizens of Serbia are not belonging to the Serb nation. So the symbol of the nation is not encompasses, it's not equally the symbol of all citizens of the state. The state symbols are symbols of the complete citizenship, but national symbol is not the same. But in Serbia and many other states in East Central Europe, the state symbols are the same as the national symbols of the state-bearing nation. So if we say that these two things are identical, the national symbols and the state symbols, it means that we have a kind of a problem how to identify those who are not members of the nation, not feeling to be the members of the nation, to identify with these national symbols. In this respect, the principle of equality of dignity requires a kind of official recognition or recognition of the symbols of those minority nations living in the country. But it's a very sensitive issue, because this recognition, particularly the official protection of the symbols of national minorities, means a kind of plurality on the ground of national symbols. It's a kind of correction of the idea that we are protecting only the symbols of the state. We are also protecting parallelly symbols which are not symbols of the state. And these symbols could be the symbols of the bordering states as well. This is what some colleagues already mentioned, that the symbols of national minorities could be also the symbols of states. And in this respect, the issue of sovereignty is also coming into place, because the sovereignty is reflected, marked also by the state symbols, which are equal to national symbols in many states. In Serbia, we have constitutional recognition of the protection of national minority symbols. It is in constitution, not on the level of law, but also on the level of the constitution. So in Serbia, the legislator, the constitutional maker tried to create a kind of balance between, in this triangle of symbols: national symbols, state symbols, and the symbols of national minorities. The question is, the particular regulation is very sensitive. Why? Because it is sensitive when we have large minorities, large numerous minorities, living concentrated in a border region with the kin state, having the same national symbols as the kin state has in concrete case. So the legislator, in a way, have to give answer how to create acceptable balance in such case. So the real challenge is in this issue, how to live together with these symbols, because the recognition and the use of national minority symbols officially is a reflection of the plurality of identities. And the recognition that we are valuing the identity of the majority nation, the state-bearing nation, and minorities in a way equally. Not with equal weight, but equally. Our approach is equality. So, after this introduction, we can formulate that we will face concrete challenges when we have to regulate by law the use of minority symbols. So it is a question, the first question is, to which extent to restrict how these symbols should look like? Is it the question for the legislator, or is it something which is done? So we have these symbols, or you have to create new symbols. The second question is, to which extent we should use coercion in this question, prohibitions, sanctions. To which extent, if someone is using these rights not according to law, or whether it's a good solution to regulate these things detailedly or very generally, and to put a little bit emphasis on the practice, and to give a judge a kind of freedom to measure the level of breaches the law or non-breaches of the law. My first concrete remark is about history. My honorable colleague, Professor Đukić, was detailedly elaborating the present regulation, how the law on the protection of national minorities regulates the issue of the national symbols, and what are the restrictions in the law on the state symbols in regard to the use of national minority symbols. But the story was not beginning with this law from 2002, but we have roots of the regulation in the constitution of Vojvodina autonomous province, socialist autonomous province from 1974. This constitution, at that time, Serbia was part of the federal Yugoslavia. It was a loosey federation with very strong republics and autonomous provinces which were almost equalized with the republics. The main difference was that autonomous provinces were not recognized as states. Republics was recognized as states. The autonomous provinces were not recognized. They had no flags, for example, like republics. But we have the provision in this constitution from 74, Article 4, is about the right for nations and nationalities to use their historic emblems and symbols. So it was a constitutional rights recognized before almost 50 years. These constitutional rights were implemented with the law of the autonomous province and also a recommendation of the Assembly of the Autonomous Province of Vojvodina. All this was terminated in 1990 when the new constitution, that time new constitution of Serbia, cut very much the autonomy of provinces, and the constitution of the province ceased to exist from 1990. My second point is about the regulation. You have elaborated and analyzed regulation, the rules about regulation. What is for me interesting is that this regulation excludes the identity of national minority symbols and the symbols of state symbols of foreign states. And this was a case before the Federal Constitutional Court of Yugoslavia, which rejected the appeal, the initiative, which challenged this provision and said the full identity of minority symbols with the state symbols will be a kind of limitation of the sovereignty of the state, because it will mean that the sovereignty is violated because foreign states are foreign states and minorities are minorities, and this provision is not contrary to the right to use national symbols. It's interesting that the Slovenian Constitutional Court in 1999 had a decision 691 in which the similar question was raised because the Slovenian Italians in Slovenia and Hungarians in Slovenia used the symbols which were identical with the symbols of Hungary and Italy, the state symbols. And the Slovenian court rejected the initiative and said, yes, they are identical, but they are not the same symbols. This is the symbol of the national minority. There is a national community, autochthonous national community, and Slovenia cannot create new national symbol. If the national symbol is one, then irrespective whether it is identical to national symbols of Hungary or Italy, the right encompasses to use these symbols. So I just quoted this decision because the Constitutional Court's approach was a different bit. What is also interesting question that in the present day regulation, the law regulates only the use of national minority symbols officially. So they are regulating only cases when the local authorities are placing these national symbols in their buildings or within their official premises, and it restricts the use of these symbols to holidays, national holidays, so the state holidays, and the holidays of the respective national minority. What is the problem for me in this present regulation? There is a question how to use these symbols outside official premises, outside the buildings of local self-governments, and when there is no national holiday or no holiday of national minorities. You can have two interpretations. The first interpretation said then there are no restrictions. So you can use publicly these national minority symbols, but not in these buildings. So the restrictions are only to these premises of authorities. But for example, private companies, cultural organization can use them permanently. The second might be interpretation, a restrictive one, which said it's not regulated, therefore you cannot use it. So they can be different approaches to this question. However, in practice, there is no case when authorities are restricting the use, not in private, because it's not completely private, because you are placing it publicly, but there are no cases when it is restricted in practice. We have problems that some minorities, for example, the Albanian minority in Serbia, has no officially a national symbol, but they are using the Albanian national flag, the flag of Albania, regularly on Albanian holidays. The authorities are not really restricting this, but it's a controversial measure. My time is out, so I will conclude my remarks with the final remarks. What is necessary? What is necessary for the proper solution when we speak about this triangle, at least in Serbia, but I think it's not the question only in Serbia. In any way, non-territorial autonomy through national councils and the right to use symbols of national minorities are steps towards power sharing. They are really steps toward power sharing between the state-bearing dominant nation on the state one hand and national minorities on other hand. So both questions are related with a kind of power sharing. And what might be desirable to find a proper balance between these two interests. So the interest of the state to preserve unity, to preserve sovereignty, and the interest of minorities for the respect for diversity and for their dignity and identity. Where is the balance? It's always a sensitive issue, but at least we have to be aware that balancing is necessary in this case. Thank you for hearing me.